So the training today basically focuses on U.S. constitutional law, meaning if you travel to other states other than Oregon, the things you're going to learn today will apply anywhere you go. If I'm going to cover something that's specific to Oregon or specific to a particular state, I'll let you know that. There are some of those things that are state by state. But for the most part, we're going to cover your Fifth Amendment right, which is your right to remain silent, your Fourth Amendment right, which is your right to be free from unreasonable searches and seizures, and then your First Amendment, which is your right to assemble together and to advocate for free speech and religion and all of those other things. We'll really briefly touch on your Sixth Amendment, which is if you are arrested for a crime, that's your right to a lawyer if you can't afford one for yourself. So the Fifth Amendment, simply put, says that you never, ever, ever have to answer any questions that anyone asks you. So no matter where you go in the world, if you are thinking to yourself, do I really have to answer that? The answer is always no. The only person that can ever make you answer a question is a judge in a courtroom. And that is normally accompanied by some things like, I'm going to throw you in jail, or you're going to be found in contempt of court. Usually you'll know far in advance that you are in one of those very, very narrow circumstances. But whether or not it's the Portland Police, the FBI, Homeland Security, private security guards, anybody who works for the state, who wears a badge, we're going to call them cops or law enforcement for the purposes of today's training, they all are categorized in this same category with regard to your rights. None of them can ever force you to answer a question. And let me just say a couple of little prefaces. Number one, I'm not advising you that all cops are bad or that you should never talk to cops. Certainly there are circumstances where that's appropriate. But what we're going to do in this training is kind of show you where the line is drawn between legal and illegal. We're not advocating you do one thing or the other. We just want you to know that these are your rights. This is how far you can go with those rights. And if you cross that line, you are potentially at risk of being arrested or potentially being prosecuted. Your Fifth Amendment right, you've probably heard from TV or the movies, I'm taking the Fifth. That is your invocation of your Fifth Amendment right to remain silent. As we go through this training, when you see the words in red, we call those your magic words. They are in the Know Your Rights brochures, and we call them magic words because we really want you to memorize these phrases for a couple of different reasons. Number one, the phrases are legalese. Lawyers wrote them. Normal people don't necessarily talk like that. Anecdotally, we have found that if people use these phrases, it generally results in a little more of a professional interaction between you and the cops because you sound like you know what you're talking about. Number two, by saying these phrases in this way, you are best protecting your rights. If you end up arrested and if you end up being prosecuted, if you've said these phrases in this way, you've given your lawyers what they need in order to defend you in the event that you have a constitutional defense. And then finally, no matter how many times you have interacted with law enforcement, the adrenaline starts pumping, you get nervous, sometimes words come out of your mouth that you later regret. The hope is that by memorizing these phrases, you are training some muscle memory in your mouth and in your tongue so that in the event you get pulled over and you're in one of those scary circumstances, these phrases will come out instead of something that I have to read in a police report that ends up being detrimental to you. So in order to invoke your Fifth Amendment right, you say, I want to remain silent, or I wish to remain silent. That is the invocation of Fifth Amendment rights. Now, oftentimes people will say things like, well, if you didn't do anything wrong, then you wouldn't need to remain silent, or, what is the right to privacy anyway? Things like that. These are constitutional rights. And an important thing to know is if we don't exercise these rights and we don't use them, then we lose them. If only guilty people are asserting their rights, then all of our rights are eroded. These are constitutional rights. They will never be used as evidence that you've committed a crime. They can't even be brought up in court. They are rights. So, and the origins of these rights were basically to protect we the people from ambiguous circumstances, basically being falsely accused of things by the state. So, one of the Fifth Amendment's basic functions is to protect innocent men or women who otherwise might be ensnared by ambiguous circumstances. Truthful responses of an innocent witness, as well as those of a wrongdoer, may provide the government incriminating evidence from the mouth. The Fourth Amendment is your right to be free from unreasonable searches and seizures, commonly known as the right to privacy, or that your home is your castle. And the magic words in order to assert your Fourth Amendment right is simply, I don't consent. I don't consent to this search. Cops can't search you, your house, your car, your possessions, unless certain things happen. And the most common way that the cops are going to get into your house and search your stuff is because you consent to it. By saying yes, or I guess you're going to come in, or anything like that, you have basically given up your Fourth Amendment right. If that search was going to be illegal, by saying the words, by not saying the words, I don't consent, you are turning an illegal search into a legal one by consenting to it. And then the other most common way that people end up having the cops come into their business is by search warrants, and we'll talk about that in a second. Now, with regard to consent, the Supreme Court has ruled that children as young as 10 can consent to the police coming into your home and searching your stuff, even if an hour later mom said no. So cops show up at the house, mom says you got to come back with a warrant, mom goes to the grocery store, cops wait and come back, the 10-year-old answers the door and says, hey little girl, can we come inside? And the kid says yeah. That just undid mom's refusal, and now that 10-year-old has just consented to a full search of the house. Guests, your friends, your neighbors, roommates, all of those people, if it's apparent that they have some kind of authority to consent to the search of the premises, then law enforcement is allowed to take that and run with it. So on the back table, we have a script that we actually suggest that you post by the door if this is something you're interested in, so that if you have guests or people that haven't gone through this training, or just if you are nervous and words escape you once you see that badge and the shiny uniform, you can just literally read from this script and be able to assert your rights. Oftentimes people feel a little more comfortable saying no to police if they can say things like, well, my lawyer told me never to consent, and you're welcome to use me as the scapegoat if you need to or want to. For any of you that live in apartments, consent is an issue that is spelled out in your lease. You have the right to consent to searches and seizures of your apartment unless your lease says otherwise. So if your lease does not say landlord gets to tell the cops when they can come in, then you're good. But like any college student living in a dorm, you have no right of consent or refusal to consent. The university owns your dorm room, they get to decide. And so it's on a case-by-case basis with leases and landlord-tenants. I would probably say about 90% of the leases that I've ever looked at do not have a provision that lets your landlord consent, just so that everyone doesn't go home and freak out if they have a lease. But often slumlords, especially in college towns, tend to put that condition into the lease. So police, like I mentioned, police can't search you or your possessions unless you consent to it. And you need to say, I don't consent, out loud and in words. Now, a search warrant is basically just a piece of paper that is signed by a judge. And the piece of paper will say when they can search, where they can search, what they can take. If you're home and they show up with a search warrant, you have the right to inspect the warrant. They'll probably be pushing you to the couch and sitting you down while they start running around your house, but you have the right to inspect that warrant. If you're not home and the police have a search warrant, then they're allowed to break down the door and enter and do the search. Oh. So if you are home and they show up and you hear police search warrant and you look out the door, you might want to open the door because otherwise they're going to bust the door down. Now, a very, very important distinction. When we are talking about ICE, Immigration Customs Enforcement, maybe some of you work with immigrant communities, ICE can never get a search warrant. ICE can never enter your home without your consent. So if ICE shows up at the door, they're not going to be able to break down the door. The only way ICE gets into somebody's home is because you voluntarily let them in, which you never, ever, ever should do, under most circumstances. So, so even if you look at the warrant and, it's got the right date, it's got the right address, but you look down and it says they can search your house, but you don't see car listed on that search warrant, and you look out the window and they're rooting through your glove box in your car. You don't want to say, oh, hey, officers, you forgot to put car on the search warrant, because they can just jump on their cell phones, call up the judge, and get what's called a telephonic warrant, where they just say, oh, judge, we forgot to put car, add car, and the judge says, no problem, car is added. And now you've just turned what would have been an illegal search into a legal search. So if you see them going beyond the scope of the search warrant, you want to keep that to yourself. You want to tell your lawyer about it. And you want to be continuously saying, I don't consent, I don't consent. We don't want you to resist the search because you will get injured, likely. You might get charged with extra crimes, but chances are they can potentially rough you up. But by saying, I'm not going to resist you, but I don't consent to this search, there are exceptions to the search warrant requirement. There are certain circumstances where they don't need a warrant. Like, for instance, exigent circumstances means like emergency. Like, cops are chasing a murderer down my street. The murderer runs into my garage. The cops do not need my consent, and they don't need a search warrant before they bust into my garage. Now, once they arrest the murderer, in hot pursuit, if they look around and then they see, my meth lab or something else illegal, they're now going to be able to bust me under what's called the plain view exception. If they see it, they're now allowed to deal with it. And there are many, many exceptions to the search warrant requirement, and they're changing all the time. So there's no way that most people are going to be able to analyze, is this legal or not, in the heat of the moment. But by saying the simple words, I don't consent, if it turns out that one of those, bases to search is not lawful, you will, give your lawyer everything that you need to fight it in court. So, I'm not going to resist you, but I don't consent to this search. And we added that I'm not going to resist you part in the last year or so, with all of the increases in cops murdering humans, we want to make sure that somebody doesn't get shot wrongfully. So, you want to, we'll talk about this in a second, you want to make sure, your hands are visible, and you want to say, look, I'm not going to resist you, but I don't consent. Say it into cameras, say it in front of witnesses, say it as often as you think is appropriate in order to protect yourself. Now, the First Amendment is your, right to religion, your right to free speech, your right to assemble, which means to gather together like we are right now. And generally speaking, especially these days, Americans really censor themselves. We view the First Amendment as far more narrow than it actually is. Now, everybody in the U.S. or a U.S. territory has the same exact rights, whether you are a U.S. citizen or not. Whether you're 8 years old or 88 years old, we all have the same constitutional rights when we are within the United States. However, if you're here on a student visa or if you're undocumented, even though you have the same First Amendment rights as I do, if you end up getting busted, the consequences can obviously be more serious for you, especially those that are here on a visa, or if you travel to another country on a visa, the small print on your visa says that you will not engage in political activity. So if all of us get busted at a protest, we're probably going to get a little baby slap on the hand, but someone here on a student visa might actually face deportation as a result of that same situation. So the First Amendment, again, allows you to gather together to pray, like at Standing Rock. A number of the protests that water protectors engaged in were couched in prayer. And prayer can look all sorts of different ways depending on, what God you believe in and how you exercise that right. It allows you to scream and yell. It even allows you to use profanity. It allows nudity. It allows you to take to the streets and the public sidewalks. It allows you to burn the American flag. And much to President Trump's chagrin, it allows you to advocate for the nonviolent overthrow of our government. Very, very broad. There are very few things that are not protected by the First Amendment. Defamation, which is also known as libel or slander, that's when you knowingly tell a lie about someone that causes them economic harm. So if I say my dentist keeps dead bodies in the basement and all of you quit my dentist and he loses all his clients, and I knew that that was not true, I've just committed defamation and I can be sued. That's not First Amendment protected. Obscenity is not just swear words. Obscenity, being obscene, is when you are saying something in the public sphere that is meant to be overly sexualized. Hate speech is protected by the First Amendment. Absolutely. You can say the ugliest, most repugnant things about anyone, and it is First Amendment protected. Now, if you combine that verbal ugliness with some other crime, like assault or harassment, then it actually becomes a hate crime, which is an enhanced penalty on a crime. So if I just call you, some terrible name, that's not, that's First Amendment protected. But if I call you that terrible name and I punch you in the face, then I'm going to be prosecuted for hate crimes. A lot of people think that hate speech is not protected. But, whether you're wearing the Nazi flag or, all of the other trash that's going on these days, those are actually protected, First Amendment rights. Now, fighting words or true threats, the distinction there is if I stand up in front of all of you and I say, let's get some pitchforks, head to Washington, D.C., and tell Donald Trump what we think of him. That is rhetoric, right? There's no pitchforks here. We're not going to get to D.C. anytime soon. And so that is sort of fiery, free speech. But if I've got a big stack of pitchforks over here and Trump is in the bathroom, and I say, let's get these pitchforks and go get Trump, and any one of you does something to him, I am now criminally liable for your crime, whether it's murder or assault or harassment or anything. So that's the difference between fighting words and true threats. If you can actually act upon it, it's not going to be protected. And then association for illegal activity. If I stand up here and say, let's all go down to that pipeline and cut it up into little pieces and lock ourselves to it, and we all then go do that, and I've said that in front of cops and the public, et cetera, I've just advocated illegal activity and I can be held liable for that. I can be charged with conspiracy. I can also potentially be charged for the underlying crime, which is why we need to recognize, that where we exercise speech actually plays an important part. And incitement or advocacy of crime, if I say, back in the abolition period, people, trespassed onto private property and did these things and shot cops and blah, 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 and I'm saying it in a historical context, then that's not the same as if I take all of you out for some target practice and, we're literally preparing to commit crimes together. Now, where we exercise free speech or where we assemble together plays an important role in how much your First Amendment rights are protected. So, for instance, the way the state will analyze whether you have a First Amendment right to free speech will be based on the type of protest and what's called, the time, place, and manner test. And so the first thing they look at is where are you exercising free speech? You have the most expansive protections in what are called traditional public forums. So sidewalks, streets, in front of the federal courthouse, national parks, forest lands. Those are all traditional public forums, meaning free speech usually happens there. It's very difficult for the state to restrict your First Amendment rights in those areas. They are held to a very strict test if they want to try to limit your rights. They can only do it under this reasonable time, place, and manner restriction. So, for instance, I might stand on the public sidewalk in front of a courthouse all day and night, and that might be okay. But if I go to a residential neighborhood at 3 o'clock in the morning with a bullhorn and I stand on the sidewalk outside of a vivisector's house and I start screaming and yelling in the bullhorn, I might have my First Amendment rights restricted under those circumstances because the state will argue that that was an unreasonable time, place, and manner in which I exercised those rights. Now, laws cannot regulate the content of your speech. A law can't say you can protest Democrats but not Republicans. If they are picking sides in any shape or form, then that is unconstitutional. They're not allowed to do that. And, to give you an example, we challenged an Oregon law that was called interfering with agricultural operations. But it was specifically intended to thwart forest protesters. And in the law, it said, thou shalt not hinder a timber sale unless you are a worker engaged in a labor dispute. And because they made that distinction, because the cops had to read your picket sign in order to figure out were you there for the labor protest or were you there for the forest protest, that was unconstitutional, and that whole law got thrown off the books. So this is one of the megalode protests where a bunch of folks went out into the middle of the highway, which is a public roadway, and sat down to protest the transport of mining equipment that was on its way to Canada. Now, you do have a First Amendment right to protest in the streets. Those are public forums. But if you block the entire street so that no one can, what's called ingress and egress, if you can't walk or drive one way or the other, then now you're committing disorderly conduct. You're blocking the roadway. The same with sidewalks. If you completely block the entire sidewalk, then they can tell you move to one side or the other, and if you don't, then they can charge you with disorderly conduct. The other thing to know, especially if you are organizing, one of the very common ways that the state will attempt to shut down protests and rallies is by what they will call health and safety. One of the reasonable time, place, and manner things that they will look to is there a health and safety concern? So if I have 300 people and no porta pots, at a protest and no running water, I have given the state the opportunity to shut down my protest because of health and safety concerns. This was like what was used most commonly during the Occupy protests. You can camp there, but if you don't have bathrooms and you don't have water and you don't have food handler cards and you don't have this and that, then we're going to shut your protest down because of health and safety. So when you are organizing protests, one of the things you need to be looking at is, who are you inviting to come? We generally at the CLDC do not believe that people need to get permits before they protest. We don't think you should have to ask the state for permission to exercise your First Amendment rights against the state. We think it's, easier to ask for forgiveness than permission, as they say. However, there can be certain circumstances where as an organizer, you might need to contemplate whether you need to do that. Like, for instance, if you're inviting a bunch of babies in strollers to come, or if you're inviting undocumented people, or, if you're inviting 5,000 people, there may be circumstances where a permit may be required or necessary. If you're an organizer, you need to look at the state laws and the city laws where you are organizing. And you should always do that. There are a couple of places in Washington state and a couple in Oregon now that have anti-masking laws. So if you go to that city, it's against the law to protest while wearing a mask, whether that is a surgical mask or a Guy Fawkes mask or a bandana. Wearing a mask at a protest can be a crime in certain places. Very limited. We're challenging them, but it's important to know the lay of the land before you're inviting others to come protest with you. If you are an organizer, that's part of your role and that's your duty to make sure that you know the lowdown before other people come and play with you. Now, even in the circumstances with megaloads, where they're shutting down the highway, normally in these circumstances, law enforcement is going to give you what's called a trespass warning or an admonishment. They're going to say, leave or be arrested. They will give you the one warning. And at that time, once they say leave or be arrested, if you don't leave, you should definitely assume you will be arrested. But at that point, if you walk off, normally you're not going to be subject to arrest. Now, this is an activist locked down to an ICE van. Even though he's in the public roadway, this is not First Amendment protected. There are two terms, civil disobedience and direct action. Civil disobedience is where you engage in a protest in order to draw attention to an unjust law. So in this case, he knows that locking down to this van is probably going to get him arrested, but he's trying to draw attention to the unjust immigration laws and the fact that those folks were on their way to a detention facility. You are going to, like the valve turners. They went to the pipelines, they turned the valves to stop the flow of tar sands oil. They knew that was probably going to get them arrested, but they were doing it to try to stop the flow of oil. That is a distinction in organizing tactics that you need to know about. Especially right now, there is sort of a myth going on about the necessity defense, and the climate necessity defense. This idea that if you break the law and you think it was a necessity, you can get out of trouble. That's largely untrue, but one important reason why I want to make sure you know the difference between civil disobedience and direct action is in order to use the necessity defense, you have to have been engaged in direct action. You have to have actually attempted to actually stop something. If I go to the courthouse and sit down and lock myself to the courthouse steps in order to protest tar sands oil, I'm not stopping anything related to tar sands oil there. That's civil disobedience. I'm not going to have a necessity defense available to me. But if I, throw myself in front of an oil tanker in order to stop that oil tanker from coming in, then I may attempt to utilize the necessity defense. But in my 20 years of doing activist defense, I've only had a judge let us use it once. And now, out of all of the valve turner cases that we are representing people on, we now have one state that is so far allowing us to present the necessity defense in Minnesota. But all the others, we're denied it. So please don't think that the necessity defense is going to be a plan to get you out of trouble anytime soon. Free speech zones, we hate these things. It's where the government basically puts a small cage together and tells all the protesters to go stand in it and show each other their signs. It's weak, but in certain Republican national conventions, Democratic national, mass protests, they are being used with more and more frequency, and the U.S. Supreme Court has said that they are constitutional.
They are constitutional?
They are constitutional, yeah. Quasi-public forums are basically this middle ground, like a university campus. There might be some places that First Amendment protection is allowed. But if I walk into a biology classroom and think I'm going to have the same right to chant and protest, probably not. So there might be some areas where it's acceptable, other areas where it's not. And then private forums or private property, you have no First Amendment rights. If you all come into my backyard and start chanting, all I have to say is leave, and if you refuse to leave, you're going to be arrested and charged with trespassing. So there is no First Amendment right on private forums or private property. Now, this includes malls, stores, shopping centers, and not just the Walmart itself, but Walmart's parking lot and Walmart's internal sidewalks are all private property for the purposes of First Amendment analysis. Now, if you're the organizer and you're thinking, I want to protest Walmart next month on Black Friday, you need to go down to your city planning office and figure out where the public right-of-ways are. Normally there's going to be a set of sidewalks out near the public roadway. Those are going to be public, not private. You'll have the right to protest there. And normally there is this strip of grass between the sidewalks and the curb that's called the public right-of-way. Any plat map, that's the map that you would want to go look at, will show you where these right-of-ways are, and those public right-of-ways are legal for you to be protesting at. So, for instance, in Eugene, there are some protests that happen out kind of in the countryside, and there's nowhere to stand except in these public right-of-ways. And so as organizers, you need to figure out where are they located, how far do they extend, and I normally recommend that you print out a copy and have it in your hand. Because when the cops show up, they're going to threaten you with arrest, and if you can whip out the map and say, look, I'm allowed to be here, and if you make me leave, I'm going to sue you for violating my First Amendment rights, then you've got some tools in your pocket. Juveniles, or those that are under 18, have the same exact rights that we do. The one big difference, though, is, if we get arrested protesting, or, for most minor crimes, we're going to be able to ask to be released on our own recognizance, meaning we're going to be able to get ourselves out of jail one way or the other. But if juveniles are arrested, there has to be a parent or guardian that comes and physically gets them. So if you and some teenagers are traveling out of state to a protest, we strongly recommend that you get what's called a guardianship authorization, which just basically said, mom, it's like a permission slip that says, I, mom, let Lauren take my kid and be its guardian for the weekend while they're in Seattle. In the event that kid somehow gets arrested, I take that piece of paper to the jail, and now kid can be released to me rather than mom having to travel up to get kid. Also, juvies do not have the right to a jury trial, and very often the punishment that juveniles will get within the juvie system for protesting is actually more severe than a lot of adult punishments, because they get house arrest and curfews and all sorts of things that really piss them off. The last case that we had some juveniles, they actually opted to be treated as adults with the rest of the activists arrested because the adults were going to get a little baby slap on the hand, and the juvies were, going to end up with like 12 months worth of like very serious probation. So interacting with cops, whether you are getting pulled over for speeding or whether you are engaging with them at a protest, remember that anything you say or do will be used against you or others in your community. And we'll go through kind of like encounters with cops in a second. People just need to remember that oftentimes in the political scene, cops are not necessarily investigating criminal activity. Very often, they are psychologically profiling a movement and its participants. They're trying to figure out what makes you tick, who are the leaders, who are the vulnerable people within a movement, so that when they want to shut something down, they know how to do it effectively. And that's one of the more important reasons why, remain silent and don't talk to cops, generally speaking. Also, do know that cops are absolutely allowed to lie to you. 100%. When they're investigating crimes, they can say that they found coke in the trunk of your car. They can say that your mom snitched you out. They can say anything in order to get you to give up information about yourself or someone else. Now, the opposite is not true. We are not allowed to lie to cops. That's called giving false information to a police officer. It's a misdemeanor. Even giving them an alias, giving them a fake name, is a crime. You want to make sure whenever you're interacting with cops that they can see your hands. If you're in the car, put them on the steering wheel. If you're out on the street, slap them down to your sides. Now, cops are murdering people, especially people of color, but they are shooting and killing people for holding cell phones, for playing with toys, for reaching for their driver's licenses. And so if you find yourself engaging with a cop, we recommend that you narrate your actions before you do them. If you're in the car, put them on the steering wheel and say, "Officer, my registration is in my glove box. Is it okay for me to reach and get that?" If the cop says yes, then do it. "My wallet, my license is in my wallet. Can I get that for you?" Yes, and then do it. If you have a concealed weapons permit and you've got a weapon in your car, you obviously want to say, "Officer, I'm a concealed weapon permit holder. My gun is here." Or, even if you have a camping knife, say, "Officer, my camping knife is in my pocket. What would you like to do with it?" Normally they'll just take it while they're talking to you and then they're going to give it back to you. But cops don't like surprises, and you kind of want to limit the adrenaline rush that a cop can potentially get. So, so just make sure that they can see your hands. Don't put them in your hoodie pockets. Don't mess around in your pockets. They don't know what's in there, and it makes them very nervous, and we want you to stay alive. You don't have to go anywhere with a cop unless they've placed you under arrest. So if the cop says, "Hey, come down this dark alley, I want to ask you a few questions," you're allowed to say, "I'd rather stay here under these bright lights with all these witnesses around. Thanks." The only time a cop can move you is once they've placed you under arrest, they've put the handcuffs on you, now they're allowed to take you to jail. Until that time, you can stay right where you are. Know that you are probably being recorded by cops, either audio or video. There are video cameras out the front of a cop car, video cameras into the back seat of a cop car. A lot of cops now have badge cams that they wear, and before badge cams, their little radio doodah was actually a one-way microphone. Now, a little note on badge cams. Badge cams are not the solution to police misconduct. The cops get to control the on and off button of this camera. So they get to turn it off, beat the shit out of you, and then turn it back on. Also know that the camera points at you, not at them. And so there's all sorts of ways, and they control that technology. So I can't tell you how many times I've heard gosh, we don't know what happened, but somehow this video has been destroyed. Oh yeah, it just so happens to show that you beat the crap out of my client when he was laying down on the ground handcuffed. Shocking. So don't expect, the cops to be protecting you when they are audio and video recording you. But also know that, like, sarcasm, does not play well in a police report. Saying, oh yeah, I killed that guy, becomes, suspect admitted to murdering victim, and then you're in a troublesome situation. When you're dealing with cops, because of that video recording thing, I always tell people, imagine your grandma sitting on your jury watching you at trial, which makes for a lot of fun games when you're talking about, like, DUI cases, where someone's, like, wasted and, doesn't remember what they've done and they're being recorded by the cops. You have an absolute right to record law enforcement. Now, if you're the one that's being cuffed, clearly they don't have to tell you that you can get to record them while they're handcuffing you. But you have the right to record others, and you have the right to record law enforcement until such time as they want to place you under arrest. We generally recommend that you say into your phone or into your camera, I am recording you. Oregon does not have a notice requirement. You don't have to ask permission in order to record the cops, because nobody has a right to privacy in a public place. Public servants doing public duties don't have a right to privacy out in the public domain. Neither do you, which is why almost every street corner in the city has a camera at this point, a surveillance camera. You don't have the right to come up to me and say, oh, delete that picture, I didn't want it. No, when you're out in public, anything goes. That's why they have the right to photograph your license plate, for instance, because out in the public domain, there is no right to privacy. Now, oftentimes people will say, like, well, how close can I get to the cops? There is no, like, one answer to that. Generally we'll tell people that you should stay about 8 to 10 feet away from the cops when they're doing their jobs, whether that's arresting someone or whatnot. But, if they're ticketing a homeless person who has a beer, you could be 3 feet away and that could be fine. But if the person pulls a gun, they could tell you to move a quarter mile away, and that could be legal. So generally what we tell you is, if the cops tell you to move back, just take little baby steps, keep filming, and when they go back to what they're doing, you can stop there. But if they say go across the street or we're going to arrest you, take them at their word. If you don't go across the street, they're going to arrest you. A few other things, you can get a good angle by holding your phone up higher. And, oftentimes cops will surround someone while they're arresting them or hassling them so that you can't film what's going on there. But if you angle up, or angle down, you can kind of see into the circle a little bit. If you catch something really important on your camera, walk away and upload it. Get it to a safe location. The cops can often try to grab phones, damage phones. As Cora and Michelle will mention, you really want to make sure that your phone is password protected. And if the cops appear to be coming for you, turn your phone off. Don't leave it alive and active, because then they're going to have access to your footage, access to your text messages, your photos, your contacts. Your whole world is on that smartphone these days. So make sure that they don't catch you with the phone unlocked, where they can now poke around your phone. And if you can upload it to the cloud or text it to yourself or email it or whatnot, it just makes sure that if somehow your phone is seized, whether legally or illegally, that at least your very valuable footage will get out, and you will be able to access it. Weapons, like I mentioned, you want to tell them if you've got them on you. Cops are allowed to do what's called a pat-down search. We'll talk about that in a minute, but that's literally just supposed to be like patting down for weapons. And a weapon can't be found in your wallet or an Altoids tin. And, we'll talk about that in a little more. We generally say be polite but firm in asserting your rights, and know that those are, in fact, your rights. And just to mention the recording cops part. that is one of those things that most states you're allowed to record cops in public. There are a few states like Arizona and Texas where that may not be the case. So if you travel to other states, this is one of those areas that we recommend look at those state-specific laws, especially if you're going to go out and cop watch. All right, so when you're interacting with cops, there's 3 different types of interactions: mere conversation, detention, and arrest. And it's important to figure out which one of these levels you are at so you know what's going on and what your rights are and what you may have to do or not do. So level 1, mere conversation. Anywhere the public can go, cops can go. And meaning, like, if the public could come into this space, cops could come into this space. If the public would not think that they could walk through my latched gate at my house, then the cops cannot walk through my latched gate. But if I don't have a gate and the post guy walks right up to my front door, then the cops are going to be able to walk right up to my front door. So anywhere the public would think they had a right to go, cops can go just like the public. And I could walk up to any one of you and ask you for your social security number. And of course, you don't have to give me that answer. You'd say, I don't have to tell you that. Cops could walk up to any one of you and ask you anything as well. But at the mere conversation stage, you have the right to simply walk away, to say, I'd rather not talk to you, and walk away. But how do you know whether you're at the conversation stage or at some other stage? And the magic words for this are basically, am I being detained? Am I being detained? If the cop says, well, no, you're not being detained, then you know you're at the conversation stage. And at the conversation stage, you don't have to answer any questions at all. You don't have to identify yourself. You don't have to stay there. You can just simply say, I'd rather not speak with you, thanks, and then slowly walk away. In Oregon, Washington, California, most of the left coast states, we do not have to carry identification ever. The only person that ever has to carry ID is the driver of a vehicle, and then of course you have to have a driver's license. Otherwise, we do not have to carry ID or show ID. And again, there are some states like Texas where it's a state law that you have to carry and present ID. Not here. So at the conversation stage, we do not have to identify ourselves at all unless we have been pulled over in our car. Now, technically, the only reason that we should be pulled over in our car is if the cop has some basis to detain you. You've committed a traffic infraction or you've been speeding. If that's the case, because you're in a car, they have the right to ask you to produce your driver's license. But only the driver, none of the passengers. In order for the cop to be able to identify any of the passengers, the cop has to be able to say why that person is also being detained, which we'll talk about in a second. So, am I being detained or am I free to go? It means the same thing, but we like am I being detained because that's lawyer land. If the cop says, well, no, you're not being detained, then you're free to leave and you should walk away. Now, if it says, am I being detained, and the cop says, yeah, then you're at the detention stage. A cop can only detain you if they reasonably believe you have committed a crime or you're about to commit a crime. So if a cop says, yeah, you're detained, that means he thinks that you have committed a crime or are about to commit a crime. And at that point, if they say, yeah, you're being detained, then certain consequences flow from that. The next thing you want to say is, well, I don't consent to the search. Because if a cop is detaining you, this now means that they are allowed to do that officer safety pat-down search. We want you to still say, I'm not going to resist you, but I don't consent. Because maybe the detention is not lawful. Maybe they don't have a legal right to detain you. And if you say, I don't consent, and it turns out they didn't have the right to to detain you, then anything they find in your pockets might get thrown out of court. So if a cop reasonably suspects you've been involved in a crime or about to commit a crime, they are now allowed to hold you in place. They are allowed to detain you. At this point, you are required to reasonably identify yourself. And in Oregon and most of the West Coast states, this means giving name, address, date of birth. That is it. Name, address, date of birth. If you don't give those 3 pieces of info when you're being detained, the cop is allowed to bring you down to the cop shop to run your fingerprints in order to reasonably identify yourself. So you do have a Fifth Amendment right. You could just say nothing, but then they're going to be allowed to bring you down to the cop shop. We generally recommend that you give name, address, date of birth. Never, ever give cops your social security number. That gives them access to a whole lot of other info that they're not normally allowed to get. And you're not required to ever give social security number. You also never want to give your immigration status or your country of origin. And in fact, in Oregon, it's against the law for them to ask those types of questions. And like I said, in Oregon, you are not required to give your ID. Now, 9 out of 10 times, if you're stopped by the cops, and I'm not talking about in your car, they're going to say, let me see your ID, right? So if you say, am I being detained, and the cop says yes, the very next thing you should do is just voluntarily say, my name is this, my address is this, my date of birth is this. And the reason we suggest this, if it gets to the point where the cop says, let me see your ID, and you say, well, in Oregon, I'm not required to give you my ID. Yes, you are. No, you're not. Yes, you are. And then you get into this power fight with the cops over your ID. It normally doesn't go well. But if you volunteer name, address, date of birth, and then the cop says, well, let me see your ID, and then you say, officer, in Oregon, we're not required to carry ID. I've just identified myself. That's the law. It kind of changes the dynamic a little bit. But the bottom line is, there is the law, and then there's common sense. And there is the law, and then there's the way cops sometimes act. And if a cop threatens to take you to jail if you refuse to produce your ID, then you need to think, is today a good day to go to jail for a few hours? We might take your case and sue that cop for illegally arresting you. We've done that a few times, get a few $100 out of it and spank the cops for violating the law. But if your choice that day is not to go to jail, then you may have to produce your ID. The reasons that we don't want you to produce your ID are threefold. Number one, in 2008, a federal law was passed called the Real ID Act that made it virtually impossible for undocumented people to get a driver's license, or for poor people to get a driver's license. And in solidarity with those people, we should not just whip out our privilege the first time we're asked. At least attempt to reduce the scrutiny that is placed on those that can't get IDs. The second reason is your ID has what's called an RFID chip on the back of it. This chip, they take your license, they run it through this scanner, and all sorts of information comes up that you're not allowed to know about. Gang affiliations, every single time you've been stopped by the cops, all sorts of secret notes that cops make so that if they run that chip, they get all this information that they would not otherwise get, if they hadn't had your ID. Now, at the detention stage, like I said, you never want to consent to a search, but they're probably going to do that pat-down search. Again, they're only supposed to be doing this for weapons. But if I've got my backpack on, they're now going to be able to open up my backpack and look in it just supposedly for weapons. We know that this is exploited all the time. But if I see the cops coming at me and I put my backpack more than my wingspan away, so the law has this test. If something is within my wingspan, I might be able to grab it and use it as a weapon against them. And so they're going to be able to pat down my clothing and search within my wingspan. So in my car, they're going to be able to look at the console or under the seat because I could reach there. They'll still need a search warrant for my trunk. If I've got my backpack on, they're going to be able to open it up and look inside it unless I have put it beyond my wingspan. If it's beyond my wingspan, they need a search warrant. So when we give this training to unhoused people, who have their lives on their backs, we tell them, if possible, if you see the cops walking toward you, keep that backpack more than your wingspan apart, and now they need a search warrant in order to search it. You still want to say, I don't consent to this search. They may do the search anyway. They may search your car. They may search the trunk. They may do all sorts of things, but you don't want to participate in it. You don't want to unlock your trunk. You don't want to put the password into your computer. Just simply say, I don't consent to the search. Don't fight them, but don't help them either. There's that. So, am I being detained? If yes, then you want to say, I don't consent to this search. Am I being detained? Well, no, you're not being detained, but if you didn't do anything wrong, you'd be happy to let me search your backpack, blah, 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 blah. Then you are free to walk away without even telling them your name. At the third level, which is arrest, the cops are allowed to arrest you if they have probable cause to believe that you have committed a crime. Probable cause basically means more likely than not. Probable cause is one person telling the cops that you committed a crime. So if my ex-boyfriend calls up the cops and says, I've got dead bodies in my basement, that could be probable cause to arrest me for that. That's how the war on drugs got so crazy. One person would have the cops, say, well, tell me someone else or you're going to jail or you're going to get convicted. And that's how, the vicious cycle of snitching becomes a problem. The other way that the cops can arrest you is if there's an arrest warrant for you, which basically means you failed to show up for a court date and a judge signed a warrant for your arrest. There are 3 different levels of crimes: infractions or violations, misdemeanors, felonies. Infractions and violations, cops can't take you to jail for those. You can't be arrested. They can give you a citation, they can give you a ticket, and ultimately you can be fined, but you can't go to jail. Misdemeanors and felonies, you normally will go to jail, they'll process you, etc., etc. So if you commit nonviolent civil disobedience in front of cops, you've just broken the law in front of them, and they're going to be able to arrest you. The same with speeding or traffic violations. If a cop witnesses you doing it, then obviously they can arrest you. But like I said, even just one other person saying that you did something illegal can be enough to get you arrested. Handcuffing. Handcuffs are very uncomfortable, but there actually is a proper way to be handcuffed in order to protect what are called your ulnar nerves, which are these nerves that go down the outside of your hands. You basically want to press your hands together like this, but behind your back. Women especially tend to twist their wrists around looking for a comfortable position. There is no such thing. But doing that, twisting your arms around, causes more impact to those nerves. If you've ever had handcuffs on and then your hands are tingly or you lose the sensation in your thumbs, that is from this nerve damage. And we've actually had to represent people who had to sue the cops because they've lost all the sensation in their hands from overly tight handcuffs. You have the right to ask cops to check handcuffs for tightness, but proper application of handcuffs, they're not even supposed to be able to get their pinky between the cuffs and your flesh. That's how tight they're supposed to be. So level 3 arrest, you have the right to a lawyer. And you should say, I'm going to remain silent, I want a lawyer. Don't consent to any searches, and invoke those Fifth Amendment rights. Put that magic bubble around you so that they are not allowed to question you any further. Having a lawyer present is important. Number 1, we go to school for a long time. We know this stuff. We're giving you expert advice. You wouldn't ask your, barber to give you, brain surgery. And the more serious the circumstance, the more serious it is that you have a lawyer present. Number 2 is just mere witness. If you tell the cop, if you want to confess and you tell the cops the sun rises in the east and they inadvertently write down the sun rises in the west, then it's your word against the cop's word now. And that's never a good place to be. So having a lawyer present, it will at least witness what you actually said to law enforcement. Oftentimes people think that you only get one phone call if you're in jail. That's not true. You get a reasonable number of phone calls in order to hire a lawyer. That could be 1 if it's 3 a.m. on a Friday and no lawyer is going to answer your phone call. It could be 30 if you're in custody and you're trying to hire a lawyer. You should definitely assume that everything going on in jail is being recorded. The jail cells, jail phones, even your meetings with lawyers are often going to be recorded. And don't forget that sometimes, especially in protest or political situations, there may be an undercover cop in your jail cell with you to try and get information out of you. If you are engaging in a protest or political action, you might see people with like a number written on their arm. That's the jail support number, or maybe that's their lawyer number. Once you go to jail, you will not have business cards accessible to you. And so if you go somewhere where it's risky, you either better have the number memorized or you have to have it written on your body somewhere. Out at Standing Rock, they were actually scrubbing people's phone numbers off their arms. So we were telling them to put it behind their knee or at their ankle or somewhere a little less suspicious. At the arrest level, they're now bringing you to jail, and they're going to make you put on fancy pajamas there. So they're going to make you remove all your own clothing. They're going to make you remove jewelry. Now you're going into this secure facility. So they're allowed to do what's called a skin search. This is different than a strip search. A strip search is where they look up your orifices, and they're only allowed to do that under very serious circumstances. But they are going to be allowed to have you remove all your valuables. Those people with transdermal piercings, they can't remove them themselves. That's actually, it goes into their flesh and then opens up like a butterfly behind, and there's a special tool that piercers have to use to get those piercings out. We've had a number of lawsuits against jails where the jailer says, take that out, and the person says, I can't, I need a piercer to do it. The jail says, either you do it or we're going to do it, and they just rip people's flesh off their face, and we sue them for that. If you are going to an action where you might face arrest, we really advise you, remove all valuables ahead of time. Wedding rings, the whole 9 yards, leave it home. The other thing that we will say is sanitize, before you go anywhere where there might be risk of arrest, either intentional or unintentional, make sure that your car is clean, your backpack is clean. Don't have your diary with you. It might not get you convicted of a crime, but the state should not be reading your diary, so leave it home. Now, once you are under arrest, now the cops are allowed to do what's called an inventory search, which is supposed to be documenting your valuables so that you don't accuse them of stealing. But this is the biggest exploited area that cops use in order to try to find dirt on you. You have the right to request to be searched by a person of your own gender, but if you are in Eastern Oregon and there's not another female cop for 100 miles around, a male cop is going to search you. You don't have a right to a person of your own gender. You have the right to request it. For transgender people, the jail system and the legal system in general is way behind the times. And the way jails will view transgender people is by their current biological anatomy. That's how you will be housed. You have the right to request to be put into segregation for your own safety. And generally, if you're there for a short stint, that's what we recommend. If you're there for a longer stint, call us and we'll help you in a more substantive way. But even if you have your driver's license changed, your birth certificate changed, if your biological anatomy has not been changed, you are going to be classified as your prior gender. Release on your own recognizance, or OR, basically means that you are trying to spring yourself out of jail. Sometimes, especially in protest situations, you may not have a lawyer to represent you at the time you're arrested, and you may need to be your own lawyer, especially for the purposes of getting yourself out of jail. So knowing the phrase, "Your Honor, I would like to be released on my own recognizance," can be an important phrase. In order to be eligible for that kind of release, you generally need to identify yourself. You should have a local address or local ties if possible. And just to say it, if I go up to Seattle for an action, I can use a local address as long as someone has given me permission to use their address. So if I'm up in Portland and, or I'm in Olympia and I ask Ryan, can I use your address for this action today? And he says yes, then I can give his address as my local address in order to help get me out of jail faster. No prior failure to appear, meaning you haven't missed court dates in the past. You don't want to have any pending cases, and you don't want to be currently on probation or parole, or they can deny you. But other than that, that is the law. The judge is supposed to be, it's a two-part test. Are you a safety threat to the community, and are you going to come back to court? If you can demonstrate those two things, the law says you are eligible for release on your own recognizance. And if they're going to impose bail, it's only supposed to be enough bail to make sure that you're going to do those two things. Now, I'm sure you've all heard of Miranda rights. You have the right to remain silent. Anything you say can and will be used against you in a court of law. Cops do not have to read you those rights. And as we talked about, they don't have to tell you the truth, even if they were giving you those rights. If they're going to have you sign a confession, they're supposed to give you your Miranda rights. But about 6 years ago, there was a U.S. Supreme Court case that said that cops don't have to read you your Miranda rights anymore. So we kind of came up with this version, this demand of rights, as a simpler way to remember them, which is, number one, I'm not going to talk to you or anyone about anything. Demand to have a lawyer present before you speak to anyone about anything. Don't answer any questions without a lawyer present. We talked about why. Don't agree to perform any tests. Don't agree to be part of a pop-up line, where they bring... The only test that you are kind of required to consent to is a field sobriety test. When you went and got a driver's license, you made a deal with DMV. They gave you a license, and you agreed to perform certain field sobriety tests when reasonably asked by a cop. That includes a breath test. If you do not consent to those tests on a breath test, you'll lose your license for 1 year, even if you end up being not guilty of any charges. So normally, we tell people, if you are pulled over in your car, that you will probably going to need to consent to the field sobriety tests and the breath test. Don't sign anything unless your lawyer tells you to. It could be a deportation order. It could be a confession. Don't sign it. The one thing that we do tell you that you probably should sign is what's called a release agreement. You will not be allowed out of jail unless you sign a release agreement. So usually we'll tell people, go ahead and sign that release agreement. If it's got wacky stuff in it, like thou shalt stand on your head on Thursdays and spit nickels, call your lawyer, we'll go into court, we'll get that changed, but you might as well sign it, get out, take a shower, call your lawyer, etc., etc. And then the one phrase, like if you can't remember anything else today, if you say, I don't waive any of my constitutional rights, you've like bare bones covered your butt. Okay, so sample conversations. At that mere conversation stage, the cop walks up to you and says, "Hey, who's the organizer of this protest today?" And you say,
"Are you detaining me or am I free to go?"
Right, and the cop's going to say, "What are you afraid of? If you didn't do anything wrong, you talk to me." And you're going to say something like, "I choose not to talk to you," and then put some distance between you and the cop. At the detention stage, it starts off the same way. The cop says, "Hey, take me to your leader. What's your name? Blah, blah, blah." And you're going to say, "Are you detaining me or am I free to go?" This time the cop says, "I'm detaining you." Now, this means that they have a reasonable suspicion that you've committed a crime or are about to commit a crime. At that point, they're allowed to do that pat-down search. At that point, you have to give name, address, date of birth. But more importantly, you also want to say, "Why am I being detained?" The cop has to tell you what is the articulable suspicion that you've committed a crime. What is this crime? If they say, if you say, "Why am I being detained?" and they say burglary, and then you get to court and they say possession of drugs, the fact that there were two different stories given will get all your charges thrown out. So why am I being detained is an important part of this equation. And then don't forget, I don't consent, I don't consent, I don't consent. Or more importantly, I'm not going to resist you, but I don't consent to this search. And then with arrest, you want to put that magic bubble around you and invoke your Fifth Amendment rights by saying,
"I'm going to remain silent. I want to contact an attorney."
Sure. Or something to that effect. And then zip it. Because if you start voluntarily talking, you've popped your bubble. And now the cops can start questioning you again. And then you'll have to just simply repeat that phrase, put the bubble back around you, and now they have to stop talking to you again.